present in the courtroom seated next to his counsel, Lawrence Lewis. I'm in receipt of Court's Exhibit 9, which is a question comment from the jury. It reads as follows. Your Honor, we, the jury, currently sit at 8 guilty, 4 not guilty. The same position we were after 1 hour of deliberation yesterday. We have concluded that we are officially not unanimous. Mr. Umberg, please show Court's Exhibit 9 to both sides. So let me perfect the record as best I can. We commenced the jury trial on Monday, August 7th, 2023. We took that entire day for jury selection. The jury was sworn in on Tuesday morning, August 8th. They heard evidence on Tuesday and Wednesday and part of Thursday morning. The defense finally rested on Thursday morning, which would have been Thursday, August 10th. After closing arguments in charge of the court, the jury began deliberating on Thursday at about 2:10 p.m. They recessed for the evening on Thursday at about 5:40 p.m. They resumed deliberations today on Friday, August 11th at about 9:15 a.m. But from 9:15 to 10:15, they reviewed a video recorded statement of the defendant. So essentially they didn't begin deliberating until about 10:15 this morning. They deliberated from 10:15 to noon and took a lunch recess from noon to 1. They resumed deliberations today at about 1 o'clock and have been deliberating from 1 o'clock until about 3:40. All right, just perfecting the record on the length of the trial and the length of deliberations at this point. What is the state's position?
Your Honor, at this point, they still, I suppose it's not a written rule, but they still have not deliberated as long as it took to try the case. The case took a day and a half, and they've had just short of a day and a half. I think the appropriate thing to do at this time is to tell them to continue their deliberations with the goal of reaching a verdict.
Defendant's response or proposed response?
Judge, I don't have a proposed response that you can give to the jury. I would object to the state's response in giving you the short answer to the question that you posed to me. I don't have a response. What I think the court should do, and I don't know if the court wants to hear from me in that regard, that's not what the court asked me. They indicated that they are at the same place they were, by my calculations, 8 hours of deliberations. They were where they are after 1 hour of deliberation. So they've been discussing the case. I'm talking about, if you believe what's in the note, they've been actively discussing the case for 7 hours, accounting for all of the time that the court is subtracting from the viewing and the questions. They've been actively deliberating for 7 hours, and they've had absolutely no movement. So I think that calls for a hung jury mistrial, but that's not the question that the court put to me. So I don't have any response for the jury. I don't think holding them hostage for another 7 hours, if that's what the state is asking for, holding them hostage for another 7 hours to see if they move from that position, when I think 7 hours is a long time to be talking about a case that is relatively simple. They have to make a simple decision about who they believe was holding the gun when the gun went off, because that's the only thing in debate. They haven't moved for 7 hours. I'd ask the court to declare mistrial, and I'm available starting Monday for trial number 3.
Well, if I take the jury's note at face value regarding the timelines, when they are saying that they are in the same position that they were in now as they were after deliberating for 1 hour yesterday, that would put them in the position that they currently are in now with the verdict as they were at about 3:00 p.m. yesterday. So no movement in reaching a unanimous verdict since 3:00 yesterday. Does either side want me to give them the Allen charge?
No.
I'm asking the state first, please. That's fine. Let me just hear from the state first. I mean, my options are, at this point, to tell them to continue to deliberate, to give them the Allen charge and tell them to continue to deliberate, or to declare a mistrial. So I think those are, I'm going to hear from the state first always. So those are the 3 options that the court sees. Am I missing any other option that needs to be considered?
No, Your Honor, the state's position is that the first option, to tell them to continue deliberating without giving them the Allen charge, is the state's preference and request of the court.
Defense response.
I think the option you're missing is do nothing. It giving you.
Well, I mean, I have to respond. So do nothing means continue to deliberate. I mean, do nothing is.
Well, when I say they sent you a note, they told you what the status is. The court is saying the court has to respond. I don't know that the court has to respond, but I accept that you believe the court has to respond, and under that scenario, if to the extent the court has to respond to the note, I guess what the prosecutor is suggesting in terms of a response. See, my position in terms of declaring mistrial doesn't require any response. If the court is going to respond, if my choices are, we're going to respond, number one, and I'm going to tell them something, which means I'm not going to declare mistrial, then I would say continue deliberating, because I would oppose the Allen charge. My preference would be declare mistrial since there has been no movement. And that's a little bit different. The way the court framed it is a little bit different than the way I framed it. I said 7 hours of deliberation in the room with the other jurors. The way the court framed it, which may be a better way to frame it, this has been on their minds for 24 hours and nobody's moved. I understand they haven't discussed it with their fellow jurors, but human beings, you may say put it out your mind. You've made certain arguments to me in the first 2 hours of deliberation. I'm at home, I'm not discussing it with anybody, but I'm still thinking about it when I come back in the next day. So I didn't give the court that argument or that interpretation. That's a different interpretation. I've been living with this 8-4 and thinking about the case to myself for the last 24 hours, which is a little bit, and I'm not saying that did happen, but that certainly could have happened, versus the 7 hours that I think that they've been actively deliberating, which I think is actual factual. And so just based on the 7 hours that they've been deliberating without any movement, I would ask for a mistrial.
And my view is not as expansive as your interpretation. I am merely stating that based on the letter, the note, it says that we are in the same position we were after 1 hour of deliberation on yesterday. So 1 hour of deliberation yesterday would put them at about 3:00 p.m. yesterday. So I'm not expanding it into overnight and thinking and all of that. I'm just saying that they were apparently, based on Courts 9, at the 8-4 split at 3:00 yesterday, and there's been no movement from the 8-4 split since 3:00 yesterday. All right, so it appears that both sides are opposed to the Allen charge, and so I will, do you want it as simple as please continue to deliberate? Hearing from the state always first, please continue to deliberate.
Yes, Your Honor, that suits the state.
Do you want the response to be that simple, Mr. Lawrence Lewis?
If there is a response,
There will be a response.
yes, Judge.
All right, that is my response, signed and dated at 3:50 p.m. Let me have Mr. Umberg show the jury my response to Court's Exhibit 9 and bring it back. We will await to see if it brings any further notes or if they will just simply continue to deliberate.
No additional questions, Your Honor.
All right, then Court's Exhibit 9 will remain with the court reporter, and we will be in recess until any further questions or a verdict.
Thank you, Your Honor.
We're in recess. Thank you.